All right, strap in, everyone, because today we're taking a deep dive into, well, a legal battle.
Ooh, exciting.
It is. It's over a patent application for, get this, a new technology called ionizable cationic lipid for RNA delivery.
That's a mouthful.
I know, right? But trust me, this case is anything but dry. We're talking about high stakes, big drama. You'll basically be right there in the courtroom with us.
Like a fly on the wall.
Exactly. So let me introduce the key players. We've got Arcturus Therapeutics. They're the company trying to patent this invention. And on the other side, we have the Assistant Controller of Patents and Designs, representing the Indian Patent Office.
Sounds like a David and Goliath situation.
Well, it kind of is. You see, Arcturus Therapeutics' application was initially rejected, but not because their invention was flawed.
Oh, interesting. So what happened?
It all boils down to a procedural issue that triggered this whole appeal.
Procedural stuff. So important in patent law.
Tell me about it. It can make or break your case, even if you've got a brilliant invention.
Absolutely. A tiny misstep can have huge consequences.
Okay, so before we get into the nitty-gritty, let's set the scene. The initial patent application, this goes all the way back to 2016.
Wow, that's almost a decade ago.
Yeah, and since then, this case has been bouncing around, hearings, delays, you name it. It finally reached the High Court of Delhi in 2023. We've got all the court documents, and trust me, it's quite a story.
I'm already hooked.
Yep.
But before we go any further, can you remind us why these procedural details matter so much in the world of patents?
Well, think of a patent like a legal monopoly. It gives the inventor exclusive rights to their creation for a certain period.
Right, it's a reward for all their hard work and investment, encourages innovation.
Exactly. But there's a catch. To get this monopoly, you have to play by the rules, and these rules are very specific.
So just having a great invention isn't enough. You got to navigate the patent process perfectly.
Exactly. And in this case, Arcturus Therapeutics got dinged because they were late submitting some extra documents and data.
Oh, so it's not even about the invention itself.
Nope. The rejection was purely procedural.
Wow, that's got to be frustrating. Imagine having something potentially groundbreaking and it gets sidelined because of a technicality.
It's like getting a penalty in a game for a uniform violation, not for breaking the rules of the game itself. It's got to sting.
So let's dive into this timeline and see how this little procedural misstep snowballed into a full-blown legal battle. What happened after the initial 2016 filing?
Well, the application went through the usual examination and review process, but somewhere along the line, Arcturus Therapeutics missed a deadline for submitting certain documents. The Assistant Controller of Patents, they saw this as grounds for rejection.
So basically, a missed deadline put this potentially game-changing invention on hold. It makes you wonder how often this kind of thing happens.
More often than you might think. Patent law is incredibly process-driven, and even minor errors can have major consequences.
High stakes indeed. But what did Arcturus Therapeutics do? I mean, they surely didn't just accept this rejection.
Oh, absolutely not. They fought back, claiming that the delay was caused by the time it took to complete the empirical studies the Patent Office requested.
So they were busy doing the extra credit the Patent Office assigned.
Interesting.
It's a bit like that, yeah.
They felt the rejection was unfair, and they decided to appeal the decision.
That makes sense. So what happened next? Where did this appeal lead them?
Well, that appeal took them all the way to the High Court of Delhi, one of the most respected legal bodies in India. The stakes were high, not just for Arcturus Therapeutics, but potentially for the future of patent law in the country.
Wow, so we're talking big implications here.
Absolutely. Now, the High Court proceedings are where it gets really interesting. We're going to hear arguments from both sides, the Assistant Controller defending the importance of those procedural rules, and Arcturus Therapeutics pleading their case, highlighting the potential value of their invention.
Sounds like a classic legal showdown.
Yeah.
It'll be fascinating to hear how they each presented their arguments and what strategies they used.
Oh, it is. It's like a courtroom drama unfolding right before our eyes. But for that, you'll have to join us for the next part of our deep dive.
Can't wait. I'm on the edge of my seat already. All right, welcome back, everyone. Now, before we jump headfirst into the courtroom drama, maybe we should take a closer look at the specific procedural issue that tripped up Arcturus Therapeutics.
Yeah, let's break down exactly what landed them in hot water. It wasn't just any old paperwork, was it?
You got it. At the heart of it all was a set of documents called written submissions, and Arcturus Therapeutics had to file these within a specific time frame. These submissions, well, they're like Their chance to lay out all the arguments supporting their patent claims, provide all the detailed technical info about the invention.
So it's their opportunity to really make their case, explain why their invention is worthy of patent protection.
Precisely. And according to the Assistant Controller of Patents, Arcturus Therapeutics missed that deadline.
Ah, so this is where those strict procedural rules we talked about earlier come into play. Even if your invention could change the world, missing a filing deadline, that's a big no-no.
You said it. What was Arcturus Therapeutics' excuse for missing this crucial deadline?
Well, they argued that the delay was directly caused by those empirical studies that the Patent Office requested, basically saying, hey, we were busy doing the homework you assigned.
It's like the classic dog ate my homework excuse, but for patent law. I'm guessing the assistant controller wasn't buying it?
Not really, no. They stuck to their guns, maintained that rules are rules and deadlines are there for a reason. Let's take a look at some of the key arguments presented by both sides in the courtroom, straight from the court documents themselves.
Sounds juicy. It's like we're about to watch a legal drama unfold.
It really is.
Yeah.
The assistant controller's position, they laid it out pretty clearly. They argued that strict adherence to the prescribed time limits is imperative to maintain the efficiency and fairness of the patent system.
Makes sense. They're all about maintaining order, making sure everyone plays by the same rules, no exceptions.
Exactly. They went on to say that granting leniency in one case, well, that could set a dangerous precedent, potentially lead to a flood of leaked submissions. It could throw the whole patent process into chaos.
It's like that saying, bend the rules for one, you gotta bend them for everyone. I can see how that could spiral out of control.
Absolutely. But now let's hear how Arcturus Therapeutics countered that argument. Their response, well, it's pretty compelling. They argued that rejecting a patent application based solely on a procedural technicality, without even considering the invention's merits, would have serious consequences, not just for the applicant, but for the advancement of science and technology as a whole.
So they're appealing to the bigger picture, arguing that a rigid interpretation of the rules, it could actually hinder progress.
That's right. They're basically saying, don't let a technicality stand in the way of something that could benefit all of humanity.
Powerful stuff. Did they offer any specific examples of how their invention could benefit society? I mean, beyond just stating its importance.
Oh, they did. They highlighted the potential of their ionizable cationic lipid for RNA delivery technology to revolutionize medicine and therapeutics.
RNA delivery, huh? Now, I know we've mentioned this technology a few times, but I think a quick refresher wouldn't hurt. Some listeners might not be familiar with what that actually means.
Yeah, good point. You want to take that one?
Sure. So RNA, or ribonucleic acid, it plays a vital role in all sorts of biological processes, like making proteins. Now, RNA delivery technology, what it does is, well, it develops methods to deliver RNA molecules to specific cells in the body.
Okay, I'm following so far. But why is that so important? What's the big deal about delivering RNA to specific cells?
Well, imagine this. Instead of using traditional drugs, you're delivering customized genetic instructions, basically fixing problems at the cellular level.
Whoa, that's incredible. It's like sending in a microscopic repair crew to fix things from the inside out.
That's a great analogy. And Arcturus Therapeutics argued that their invention, it represented a major step forward in this field, potentially leading to breakthroughs in treating a wide range of diseases.
So it's not just legal arguments here. They're painting a picture of the potential benefits their invention could bring to the world.
Exactly. They're asking the High Court to look beyond the letter of the law, consider the wider impact.
So we've got the assistant controller championing those procedural rules, upholding the integrity of the patent system, and we've got Arcturus Therapeutics pleading for flexibility, arguing that the potential benefits of their invention, well, those outweigh a simple procedural misstep. It's a real clash of ideologies.
It is. It's a classic battle between bureaucratic process and the spirit of innovation. Who won this round?
Well, that's what makes this case so fascinating. The High Court, they didn't just rule in favor of one side or the other. They decided to send the case back to the assistant controller for a fresh hearing.
A do-over, like a rematch.
Yeah.
But with some specific instructions from the referee this time, right?
You got it. The High Court basically gave the assistant controller a second chance, but they emphasized the need to balance those procedural rules with a fair assessment of the invention's merits.
Trying to find a middle ground, huh? Acknowledge the importance of both process and innovation.
Absolutely. And they went a step further, invoking the principle of natural justice, which is all about fairness and ensuring everyone gets a fair hearing.
So it's not just blindly following the rules. It's about making sure the decision-making process is fair, takes everything into account, including the potential benefits of the invention.
Exactly. The High Court sent a clear message. Procedural rules are important, but they shouldn't be applied so rigidly that they stifle potentially groundbreaking innovation.
It's a good reminder that the legal system, at its best, it should strive to be both just and practical. This deep dive, it's really giving us a glimpse into how the legal system grapples with these tricky issues. But we're not done yet. When we come back, we'll explore the broader implications of this case and what it might mean for the future of patent law in India.
Welcome back to the Deep Dive, everyone. We've been digging into this fascinating patent case, Arcturus Therapeutics and their RNA delivery tech. It's crazy how a procedural hiccup can turn into such a legal roller coaster.
Yeah, and what's interesting is how the High Court's decision, it might not set a legal precedent, but it could still influence how patent cases play out in India going forward.
That's a good point. So even though this specific ruling doesn't automatically apply to other cases, it could still impact how patent examiners approach similar situations in the future.
Exactly. By sending the case back for another look and emphasizing, the balance between procedural rules and actually assessing the invention's value, the High Court sent a pretty clear message. It's like they're saying, hey, rules matter, but let's not forget about the bigger picture.
Yeah, don't get so lost in the fine print that you miss out on potential breakthroughs. Do you think this decision, does it reflect a growing awareness of the need to nurture innovation, especially in fields like RNA delivery technology?
I think so. India is becoming a real powerhouse in science and technology. And to support that growth, you need a patent system that finds that balance, protecting intellectual property rights while also encouraging new technologies.
Right. Got to create an environment where these groundbreaking ideas can thrive, not get bogged down in bureaucracy. It sounds like India is moving in that direction, at least based on this case.
I agree. This case could be a turning point, encouraging a more flexible approach to patent examination. It definitely highlights how important human judgment is and considering the impact on society, even in a field as technical as patent law.
This whole deep dive has really been eye-opening. The patent system is way more complicated than I realized, and finding that sweet spot between following the rules and fostering innovation, that's so crucial. We've seen how a seemingly simple procedural issue can set off a chain reaction, legal challenges and potential consequences.
It goes to show that even in these highly technical fields, human judgment and focusing on the greater good, those are still essential.
All right, and now for the final thought we like to leave our listeners with. This case, it really highlights that constant tug of war between strictly following rules and judging things based on their actual merit.
Yeah.
Is striking that balance always easy? What are the potential downsides of being too rigid or too lenient in these situations?
That's a question worth thinking about. It's a dilemma that goes way beyond patent law, touches on the very core of decision-making and justice. We'd love to hear your thoughts on this.
Thanks for joining us on this deep dive into the world of patent law and innovation. It's been an incredible journey with you.
The pleasure was all mine. These discussions are always so stimulating.
And to our listeners, keep those questions coming. We'll be back soon with another deep dive into a new and fascinating topic. Until then, keep exploring, keep questioning, and keep learning.